Can my non-citizen spouse inherit my assets without estate tax? Have you ever wondered what happens to your assets when you pass away, especially if your spouse is not a U.S. citizen? This is an important question that many couples face. When a U.S. citizen dies and leaves assets to a non-citizen spouse, things can get a bit tricky regarding estate tax. Unlike a U.S. citizen spouse, a non-citizen spouse does not automatically benefit from the unlimited marital deduction. This deduction allows a U.S. citizen to pass on any amount of assets without incurring federal estate tax. For a non-citizen spouse, the situation is different. They can only inherit up to $60,000 without facing estate tax on the amount above that. If the assets exceed this limit, the estate tax rates can reach as high as 40%. So, how can you navigate this? One effective strategy is to set up a qualified domestic trust, often referred to as a QDOT. This special type of trust allows the U.S. citizen spouse to transfer assets to the non-citizen spouse while deferring estate tax. The assets are held in trust for the non-citizen spouse's benefit, and estate taxes are only triggered when distributions are made or when the surviving spouse passes away. This can be a great way to manage your estate without facing immediate tax consequences. Another important factor to consider is the domicile status of the non-citizen spouse. If they are considered a U.S. domiciliary, such as a green card holder who has lived in the United States for a significant period, they may be treated similarly to a citizen spouse. In this case, the estate can utilize the full federal estate tax exemption amount, which is currently $13,601,000 in 2024. However, if the estate value exceeds this exemption, estate tax will apply to the excess unless planning strategies like QDOTs are in place. For couples where one spouse is a non-citizen, careful estate planning is essential. This includes establishing a QDOT to take advantage of the marital deduction benefits, fully utilizing the lifetime gift and estate tax exemption, and reviewing jointly owned property arrangements. It is also wise to consult with an estate planning attorney who specializes in elder law and cross-border tax issues. They can help navigate the complex rules surrounding domicile and ensure your estate plan reflects your unique situation. In summary, a non-citizen spouse cannot inherit assets without facing federal estate tax like a U.S. citizen spouse can. However, with proper planning, especially through the use of a qualified domestic trust and understanding domicile status, it is possible to defer or reduce estate tax liability on assets passing to a non-citizen spouse.